Welcome to This Week in Money, the source for market opinions. Here is Jim Goddard.
We're going to be talking about the issue of rights offerings and other measures taken to make investing on the junior markets easier. My first guest talking about this will be Peter Brady, Executive Director of the BC Securities Commission. We'll also hear from Shayne Nyquvest, the Vice President of Mackie Research, and Rory Godinho, a partner at the Miller Thomson law firm. First of all, Peter, welcome to This Week in Money.
It's a pleasure to be here.
Peter, is the BC Securities Commission working on reducing the regulatory burden for the junior markets?
Yes, absolutely. The British Columbia Securities Commission has a dual mandate, Jim, and we're here to protect investors, but equally important is our mandate to have a good environment where companies can raise money, and we have fair and efficient capital markets as well. So venture markets, Jim, are incredibly important to British Columbia. We're home to about 50% of the companies that are listed on the TSX Venture Exchange, about 50% of the companies on the Canadian Securities Exchange, and we're talking about 1,000 public companies that call BC home. And in fact, about 50% of the market cap of those exchanges is also based here in BC. And one of the things I'd like to talk about, and one of the big ways we've been working on reducing regulatory burden, is by leading a national project to streamline the rules for rights offerings. We brought those rules into force in December 2015, and by about a year later, 30 companies had raised about $250 million, most of them junior companies. And in comparison, for the 7 years before that, maybe 13 companies a year on average were doing rights offerings. And those new rules that we brought in have also reduced the time to do a rights offering from about 85 days down to 38 days. So it's been a big win-win-win. It's good for investors, good for dealers, and it's good for companies.
What other initiatives has the BC Securities Commission been working on?
Well, in addition to rights offerings, we've had a new capital raising rule called the Existing Security Holder Exemption. We've done another one called the Investment Dealer Exemption that, supports retail investor participation in the markets. We've got a live project right now in which we are consulting across Canada on options for reducing the regulatory burden on all public companies, including junior ones. That could be how to raise money more efficiently, how to reduce the ongoing disclosure requirements, eliminate duplication, more electronic delivery. And we're strongly encouraging people to send in comment letters on that. And I also want to mention we've done something recently where a lot of investors are holding defunct securities, and often sometimes these are junior companies, and things didn't work out, and they're still getting statements, and we've adopted rules to allow those securities to be sold to dealers. Clients can stop getting statements they don't want to receive and get a tax loss. So there's just a number of things that we've done over the years to help the junior markets. Lastly, I want to mention our 4-month hold period project. We heard that this was an issue from junior companies for capital raising, and so we've been looking into whether we can adjust that as well. So we always want to hear from people involved in the junior markets, the companies, the dealers, the investors. The people that are doing it know best what could change, what could be better, and so we really, we have a number of projects on the go, but we're always open to hearing about more ideas.
For the financing of junior companies, what's the difference between a rights offering and a private placement?
So for a private placement, that is a company raising money, and they're not using a prospectus, a comprehensive offering document that's filed with Securities Commission. The company will instead rely on something called a prospectus exemption. So it's limited to investors who qualify for one of those. And the classic example most people would have heard of is the accredited investor exemption. And when an investor buys a security from a company in a private placement, they've got a 4-month hold period. They can't sell it even if the company's listed for 4 months. And very frequently there's no disclosure document that goes with that transaction. And in some cases, they can be quite fast, depending on the exemption that they use. So the difference with a rights offering is that the company is granting all of its shareholders the right to acquire more securities of that company on a proportionate basis. One big difference with a rights offering is that the securities are free trading. There's no 4-month hold period. They can sell securities that they acquire from the company right away if they choose to. There are some disclosure documents with a rights offering, a notice, and a circular that investors receive.
What are the benefits of using rights offerings to finance junior companies?
So rights offerings tend to be quite attractive to investors for a couple of reasons. As I mentioned, the shares that you get under a rights offering are free trading, so that's always a benefit. More liquidity is better than less liquidity in almost all situations. And there's usually a significant discount with rights offerings as well. And another big feature of rights offerings is they're often considered to be the fairest kind of offering. So every existing investor in the company gets notice of it. They get the opportunity to continue to participate in that company, like maintain their ownership share. So the offering is made on a proportionate basis, and so if you want to maintain your position in that company, you can do that. Sometimes we do hear when companies raise money, they then do a subsequent financing, and somebody can actually get control of the company through that subsequent financing. So the good thing about a rights offering is if you put money in before, but you want to maintain your position in that company, it allows you to do that. And in fact, rights offerings have really taken off in some jurisdictions like Australia. They've become almost the main way of raising capital, and because of some of the good features that I've just mentioned. And we'd be thrilled if they took off to that extent in Canada as well.
Peter, thank you so much for being on This Week in Money.
Hey, it's my pleasure. Thank you for having me.
My guest has been Peter Brady, Executive Director of the BC Securities Commission. You can find them online at bcsc.bc.ca. And continuing on the issue of rights offerings, we have on the line Shayne Nyquvest. He's the Vice President of Mackie Research, and Rory Godinho, partner at the Miller Thomson law firm. First of all, we'll talk with Shayne. Shayne, when it comes to the investors, how do they benefit when it comes to rights offerings?
Yeah, well, rights offerings are, to start with, the concept is not new to the industry. Australia has been doing rights issues, and in fact, probably 80 to 82% of their total financings are all done via rights issues. The reason for that is they are the fairest way to treat all shareholders. Whether it's in the event of a rollback or a merger or whatever it is, and the biggest change in rights issues is it used to be a full prospectus required. And the rationale of, who needs less information than an existing shareholder who probably knows more about the company than the broker who sold it to him is the rationale for the change. We applaud the BCSC and all those involved for getting this through. It's now a 5-page disclosure document, roughly, and it, outlines the use of proceeds, the terms of the issue, the dates. So it's probably 1/10 of the cost, and it's without a doubt the fairest way to treat all shareholders, which is is undisputable in that respect. So I think the concept of trying to raise larger pools of capital in the day and age of, reduced independent brokerage firms, wealth management money, banks, concept of wealth management and people's inability to manage their own financing. This is a way to allow shareholders to participate on the same basis of insiders and anybody else, and whether they subscribe for their rights or not. If they don't subscribe, other people can oversubscribe. If there's a large portion of rights being issued to insiders who are not planning to subscribe, that allows you to go, if it's a semi-mature deal that is moving down the food chain and has some institutional appeal, you have the ability to, knowingly that there's enough blocks of stock that can bring in some larger orders and accommodate them. It's just useful in a variety of ways and methods. Name of the game at the end of the day is how do we make bigger ones out of little ones, and how do we raise enough capital to do that? Raising small blocks of private placements is old school. It doesn't advance the companies, and it's time constraining. The exempt purchaser rule is, constantly maligned and, misguided EMDs who, have exempt purchasers sign here, whatever, is a bad system for exchange management and regulatory. This is very simple. It's shareholders of record as of a certain date have a right to participate. Doesn't matter whether they're exempt or not. They participate on the same level as everybody else. So the lawyer or the young lawyer who's now been articled isn't exempt, has the same chance to increase his net worth through wealth creation, not wealth management, is very well served by this exemption. The bottom line is, how do we raise bigger pools of capital to advance growth in venture companies, and how do we find the next 20% of the TSX 300? So this exemption is one of the best that I've seen to try and accomplish that. And, there's some other new things being worked on. There's an early warrant exercise program that's being brought in on a couple of fronts. It's another good way of expanding and increasing the amount of capital raised for various projects, whether they be mining, oil and gas, industrial, telecom. Doesn't matter, that the concept is the same. Anyway, that is a pretty general overview.
Now over to Rory Godinho. Rory, on the legal side of things, how do rights offerings benefit investors, brokers, and the company?
Well, as Shayne has mentioned, I think the rights offerings are a facility which allow free trading shares to be issued to existing shareholders of the company. And so when you compare them to private placements, I think investors tend to prefer not having a hold period. There's a bunch of different ways of getting to that. You can do special warrant offerings, short form offerings, prospectus offerings. The rights offering is probably now one of the simplest forms of those types of transactions because they've updated the form requirements for rights offerings so that it relies on continuous disclosure. And so the actual rights offering circular is a very short 10-page or so circular that just sets out the basic terms. So I think from that perspective, investors are interested, and especially it gives existing shareholders an opportunity to participate in a turnaround or in a situation where a company, where maybe they need to, or they want to have an opportunity with a lot of the turnarounds that are occurring now to participate in sort of reorganization of companies. So we're seeing a few rights offerings that follow consolidations, where traditionally, insider groups would have taken most of the placement or the new placement, and instead they're doing some rights offerings, which gives all the people an opportunity to participate. So I think that helps from the investor side. As far as the brokerage firms are concerned, they can act as standby guarantors. They can come soliciting dealers and help facilitate exercise. So I think that gives them an opportunity to backstop companies that they feel are going in the right direction. And so that's mainly I think, and for the companies, obviously, it's an opportunity to raise money in a relatively cost-effective manner.
Rory, thank you very much.
You're welcome.
We've been chatting with Shayne Nyquvest, Vice President of Mackie Research, and Rory Godinho, Partner at the Miller-Thomson Law Firm. And we'd also like to thank Peter Brady, Executive Director of the BC Securities Commission. And that wraps up our show for this week. Once again, we'd like to thank our guests, Peter Brady, Shayne Nyquvest, and Rory Godinho. And thank you for listening. If you have any questions for the show, you can email us at info@howstreet.com. I'm Jim Goddard. We'll be back next week with more This Week in Money.
Comments made on This Week in Money are an expression of opinion only and should not be construed in any manner whatsoever as recommendations to buy or sell any financial instrument at any time. Archived online at talkdigitalnetwork.com. This Week in Money is a production of How Street Media Incorporated. Executive producer is Tom Allen.